back from our break to this week in Civics with the Bill of Rights Institute. My name is Rachel Davison-Humphreys. I'm Director of Outreach here at BRI, and we're so glad you join us every Monday morning. We know that citizenship and education about citizenship is such hard work. BRI is here to help, and every week we have what's happening in civics and history and at BRI live on Twitter, Facebook, YouTube, and soon Instagram. And we'd love to hear your questions. Reach out to us on all those platforms and we'll get back to you. Again, my name's Rachel and I'm your host every week, every Monday. And this month we are taking a look at the Lesbian, Gay, Bisexual, Transgender, and Queer Pride Month, usually just referred to as Pride, specifically Obergefell and Hodges, the Supreme Court and inalienable rights. So every person who went to public school in the US likely knows the following words: I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. So now the pledge itself has a fascinating history of political rhetoric. I link to an article about Frances Bellamy, the author of the pledge, in Smithsonian Magazine. It's a fantastic read. And regardless of what you think of the pledge, that idea of liberty and justice for all is a ringing call to the purpose of government for many Americans. So with June being Lesbian, Gay, Bisexual, Transgender, and Queer Pride Month, again, usually just referred to as Pride, June has, we wanted to talk about this idea of liberty and justice for all. So June has always been an important month for the LGBTQIA community, with many anniversaries, both celebratory and tragic. We wanted to take a look at some of the Supreme Court cases that have sought to protect the LGBTQIA Americans from discrimination. So if you're an educator or just a person interested in the Constitution, and you don't teach or know much about Obergefell v. Hodges, the landmark marriage rights case from 2015, I can't recommend it enough as an exploration of the division of power. It's a very tight decision. It was a 5-4 decision. What's interesting about the case is that each dissenter gave their own written dissent, and it's an excellent starting place for the discussion of the role of federalism and the courts and civil rights and the role of government generally. So quickly, here are the facts of the case in Oye, linked below. So if you want to find this, it's in the comments. So here's what Obergefell versus Hodges was about. So groups of same-sex couples sued their relevant state agencies in Ohio, Michigan, Kentucky, and Tennessee to challenge the constitutionality of those states' bans on same-sex marriage or refusal to recognize legal same-sex marriages that occurred in jurisdictions that provided for such marriages. The plaintiffs in each case argued that the state's statutes violated the Equal Protection Clause and Due Process Clause of the 14th Amendment. And one group of plaintiffs also brought claims under the Civil Rights Act. In all the cases, the trial court found in favor of the plaintiffs. The U.S. Court of Appeals for the Sixth Circuit reversed and held that states' bans on same-sex marriage and refusal to recognize marriages performed in other states did not violate the couple's 14th Amendment rights to equal protection and due process. Thus, it was elevated to the Supreme Court, on June 26th, 2015, it was decided. Again, one of the many reasons that June is Pride Month. So if you're looking for resources for how to talk about this with students, I actually found that the U.S. Equal Employment Commission is the best place to go. They have 2 really awesome articles, What You Should Know, the EEOC, and Protections for LGBTQ plus workers. So here it states that Title VII prohibits discrimination because of an individual's sex. And then it goes in and gives examples of why that would be the case. And so in Bostock v. Clayton County, Georgia, 2020, so this is a very recent case, the Supreme Court held that firing individuals because of their sexual orientation or transgender status violates Title VII's prohibition on discrimination because of sex. The court reached its holdings by focusing on the plain text of Title VII to reach its conclusion. So again, this is the U.S. Equal Employment Commission explaining to employers that they cannot discriminate because of this legal precedent. For example, if an employer fires an employee because she is a woman who is married to a woman, but would not do the same to a man married to a woman, the employer is taking an action because of the employer's sex, because the action would not have taken place but for the employee being a woman. Similarly, if an employer fires an employee because that person was identified as male at birth but uses feminine pronouns and identifies as a female, the employer is taking action against the individual because of sex, since the action would not have been taken but for the fact that the employee was originally identified as male. So again, in Bostock v. Clayton County, Georgia, the court did note that there's an exception that does not, the decision did not address religious liberty issues or the First Amendment, Religious Freedom Restoration Act, that has exceptions for Title VII, provides for religious employers. Again, the U.S. Equal Employment Commission has this article that is a really great starting place for students to understand. Again, it's written kind of in plain language. It also has another article that I found to be fantastic, which was examples of court decisions supporting coverage of LGBT-related discrimination under Title VII. It starts way back in 1989 with the Price Waterhouse v. Hopkins case, which was about a woman who was unlawfully discriminated because she did not act as a woman should act and was not made a partner until, or was told, among other things, that she needed to walk more femininely, talk more femininely, and dress more femininely in order to secure a partnership at Price Waterhouse. So that kind of starts off these questions about sex discrimination. And then it catalogs three sections where it looks at Supreme Court decisions on the scope of Title VII sex discrimination provision, federal court decisions supporting coverage for transgender individuals as sex discrimination, and federal court decisions supporting coverage for sexual orientation related discrimination as sex discrimination. So again, fantastic resource to go through with your students and have them really understand the case law that supports this idea that we all should be treated, liberty and justice for all, equality in our courts as relates to employment. If you're looking for something lighter, I do recommend ACLU has a great beginner guide and brief history of LGBTQ rights cases in the US Supreme Court. It's a little bit more editorial in its commentary, but it is shorter and a good starting place. BRI also has an excellent starting point. We have a fantastic essay from our Life, Liberty, and the Pursuit of Happiness digital textbook, which looks at all of US history in hundreds of activities and essays and resources. One of the essays is on the gay liberation movement. It's by Professor Jim Downs of Connecticut College, and it looks to explain how and why various groups responded to calls for the expansion of civil rights to gay rights from the 1960 to 1980. So it looks at this very narrow window of the gay liberation movement. It ends with this paragraph, which I think is a really beautiful moment to look forward. Where he says the political activism of the 70s and 80s began to change public attitudes about LGBTQ people in American society and led to significant changes in public policy. In Lawrence v. Texas, 2003, the Supreme Court legalized same-sex sexual activity. Only 2003, it was legalized universally. In 2010, Congress permitted gay people to serve openly in the military. That was only 11 years ago. In 2013, the Supreme Court struck down the Defense of Marriage Act in US v. Windsor, and Obergefell v. Hodges in 2015 made same-sex marriage legal under the Equal Protection Clause of the 14th Amendment. Attitudes continue to change, and there is an ever-growing acceptance of LGBTQ people in America. So I want to end our conversation this morning with an excerpt from the proclamation. On June 1st, President Biden announced a proclamation on lesbian, gay, bisexual, transgender, and queer Pride Month 2021. So I'll end with these words. During LGBTQ Pride Month, we recognize the resilience and determination of the many individuals who are fighting to live freely and authentically. In doing so, they are opening hearts and minds and laying the foundation for a more just and equitable America. This Pride Month, we affirm our obligation to uphold the dignity of all people and dedicate ourselves to protecting the most vulnerable among us. Regardless of your politics, I think that is a good call to action. And I leave that with you this week. I'll be here next week, and then we'll go on a bit of a different schedule for the summer. But I look forward to hearing from you. I'm here every week during the school year. So comment, let me know what you thought of this episode or previous episodes, and I look forward to hearing from you. Again, my name's Rachel.